Okay, so
Aha.
we're live now. Uh, Now officially, thank you very much indeed, Professor Gerald Postema, for being here with us today. We are indeed honored to have you here. We are admirers of your work, of your intellectual journey. We have some. I myself have a lot of similarities in my thinking. You are one of the most influential theorists to my approach to legal philosophy, along with Professor José Reinaldo, who is here with us today. Uh, so I'd like to officially introduce Professor Gerald Postema. He holds a chair in law and philosophy. He's affiliated with the University of North Carolina, and he's now going to talk to us today about his idea of law as artificial reason. So, Professor Gerald Postema, thank you very much for being with us here today. As I said, we are indeed honored to have you here, and the floor is absolutely yours. You can take as much time as you need to talk for us today. Thank you very much.
Well, thank you so much to you and to the others who have organized this talk. And it is a pleasure to be back in Brazil again. I think most recently I was in Belo Horizonte, um, and earlier in Curitiba. I may have had some talk in Sao Paulo, but I can't remember. It was some years ago. Anyway, it's lovely to be back, and I'm grateful for the opportunity to talk and for the honor of being able to address you. You're right. Um, I want to talk to you about um, the title is Law as Artificial Reason. um, what I should say is, I have I have been thinking lately about how I might pull together a number of themes from my work over the years into something that might be kind of compact and um, easily accessible, as opposed to all the papers all over the place. Um, and this was my first attempt to kind of condense some of my thoughts and some worries I might have about it into one lecture, or it turns out it was two lectures which I've combined into one. So let me begin. um, from its earliest beginnings, theoretical reflection on law has relied on various images or archetypes to prompt and structure explanations of law's diverse phenomena. In classical thinking, these images clustered around two polar notions: power and reason. For the skeptical, law was only a mask for power. For the committed, it represented commands of a sovereign, in the sense that power was articulated as orders enjoying some legitimacy because they are issued or were issued by one with authority. Pardon me. For others, law or jus or droit or recht or derecho captured the idea of law as reason, something opposed to rather than a qualification of power, an ordering of the moral and political world on the model of the rational ordering of the universe. These classical images, both of them, portrayed law as austere, set apart from ordinary experience, set over those who are subjected to it. They represented experience of law as a kind of alienation, as other people's power, or as Holmes once put it, a brooding omnipresence in the sky. Now, some contemporary images retain that austere demeanor. So law is conceived of as a hierarchically structured system of norms, as organized and orderly knowledge of the legal universe. But sometimes it's rendered more approachable, even domestic. So, for example, you can think of Herbert Hart here, law is a matter of rules or conventions, like chess, or a union of primary and secondary rules. Right? Some think of legal reasoning as akin to writing a chain novel, to work it, or following a melody, something I've said myself. These images resonate to some extent with our ordinary experience, but they have obvious limitations, focusing our attention on certain aspects of legal experience, they nevertheless blur or distort or blind us to other potentially important aspects. However, I believe legal theory really cannot do without images. So, in this lecture, rather than offering a way of thinking about law stripped of images, what did Matt's title? Without trimmings? I want to offer and explore a different but less familiar image. Now, 17th century English common law jurists were fond of characterizing their law as artificial reason. Artificial now, not as fabricated or false, but as the work of an artisan, a craft, made perhaps, but not merely made up, and embedded in the history and daily quotidian practices of political communities. It was reason, but understood not as some transcendent ordering of the moral or legal universe, but as reasoning, as a disciplined activity in which legal rules get their meaning and force. I propose to examine this image, the image of law as a multi-layered discipline of deliberating and reasoning together regarding public matters. I call it a disciplined practice of public practical reasoning. Right? To begin, a practice, indeed a normative practice. Let's start with the idea of practice and then talk about normative practice. A practice can be viewed from the outside as regularities of behavior. But as Harp insisted many years ago, participants take what he called an internal point of view on those activities. Internal must be understood here not in the sense of something interior to participants, their attitudes or beliefs or endorsements, but rather in the sense of matters that are internal to the practice, to the activity of participating in that practice. So, practice activities are actions that are meaningful and normatively charged. They're charged not by virtue of convergence of participants' attitudes, but by virtue of their mode of participation. Thus, what sustains the practice are not individual endorsements, their attitudes or beliefs of the practice, but the interactive engagements of the participants. The way that individuals' actions are taken up by others, responding to it, affirming, refining, challenging, extending, or narrowing it. So to participate in a social practice on this understanding is to engage in the conduct of participants oriented towards each other, to their respective understandings, based in part on anticipating the understandings of the other participants. It involves grasping the significance of some pattern of conduct and recognizing its application to the present circumstances against the background of intermeshing anticipations and understandings of other participants. So, social practices have significance not just to this or that individual participant, but to participants in common. Not, to use one philosopher's language, not to we each, but to we together. Not we each, but we together. So participants ask not what are they, the others, doing, or what am I doing, but what's my part and what we are doing. Moreover, practices are dynamic. They unfold over time, producing a common stock of meaningful conduct. I call it a kind of commons of the mind, if you will. Participants contribute to them and they draw from this commons. To participate in a practice then requires mastering a discipline, a learned combination of habits and skills and dispositions. And learning that discipline, the discipline of a social practice, is somewhat like learning a language. One doesn't merely, in learning a language, one doesn't merely acquire a repertoire of routine responses to routine situations, like memorizing stock phrases from a traveler's phrase book. Rather, one develops a capacity, an amazing capacity, really, to express utterly novel sentences and thoughts. So, learning how to participate in a social practice, in doing so, one learns how to move around, if you will, move around with relative ease in the common world of that practice, moving from a grasp of what we typically do, determining what I should do in novel circumstances. Now, with regard to the normative, participation in the practice engages and exercising its discipline has a normative dimension. It involves competent performances. That's a Brandom phrase, Robert Brandom phrase. And these participants undertake certain commitments to judge certain performances as appropriate or correct, and others as mistaken, commitments to act when the occasion arises in accordance with those judgments, commitment to challenge conduct that falls short of those judgments, and to recognize appeals to the judgments as vindications or valid criticisms of their actions. Now, these commitments are normative and intersubjective. They're normative because to take commitments of this sort, to make those commitments, is to take responsibility for one's own actions and judgments, and to assess one's actions and judgments in light of this assumption of responsibility. They're normative. They're not just descriptive. They're intersubjective because they propose a relationship amongst the participants, a reciprocally recognized standing to hold each other to that responsibility. We place ourselves under the authority of practice and their norms, not by abandoning our judgment and transferring it to experts, but rather by engaging together in offering and assessing claims with respect to what the practice requires. Normative practices come in different shapes and sizes, of course, with different kinds of and degrees of personal or social or moral significance. These practices can range from rituals of greeting, of giving gifts, of making vows or promises, forming cues. An especially rich example, to my mind, can be found in the work of a jazz ensemble. This work is richly improvisatory, complexly structured coordination. Players think as members of a team, working out on the fly their musical responsibilities within the broad structure of what they call the tune and the scope and direction of their improvisations. This requires of each player constant reading, interpreting, anticipating, and adjusting. Jazz ensemble playing involves a kind of common thinking and common acting, a form of, as one um, commentator on jazz calls it, a form of reasoning together in real time. Now, we can think of the social practice characteristic of law on analogy to the jazz ensemble, but there is one really important difference. Jazz involves a kind of deliberate thinking, but its language and its logic is musical. Law's practice is fundamentally articulate and discursive. I want to explore those features of the special discipline of law. But first, in order to understand why law's social practice takes this shape, we need to consider law's modus operandi. All right. So that's what I want to focus on now. Law's modus operandi, which I'm going to say is normative guidance. Right. So law is a social practice. Thus, it is normative in the sense that performances in the practice are governed by standards of competence. That's what we've said just a bit ago. But it's also normative in another sense. Law seeks to provide normative guidance to members of the law's community. That's its modus operandi. Mind you, this is not one or even a major function of law. It's not an aim of law. It's rather the manner, the technique, and the means by which law serves its various goals. Law seeks to order social life by influencing the conduct of individuals and social groups, but it does so not by causing it or manipulating the psychological determinants of behavior or altering the natural and physical environment of deliberation. Law seeks to order social life rather by engaging the deliberative capacities of law's subjects. Addressing those subjects, law seeks to guide rather than goad. Guide rather than goad. And it does so not by describing desirable behavior and indicating a path one might take. Rather, it prescribes measures by which subjects of the law are meant to guide their practical decisions and assess their actions. It seeks to engage the practical reasoning of subjects of law by articulating norms and reasons that they can grasp and appreciate and then incorporate into their deliberations. It doesn't necessarily determine their decisions and actions, but it provides answers to questions about what they ought to do. In this way, law treats them as its subjects rather than subjecting them to it. The aim of normative guidance is not to produce behavior, but to influence deliberation and therefore thereby influence conduct. Now, law is set to work in political communities, and this determines in part the character of law's normative guidance, and it does so in several ways. Let me mention, at least three. All right. First, law typically law's directives are addressed not to law's subjects individually, one at a time, as it were, but to the public at large, of which they are members. The guidance it offers is addressed to individuals engaged in complex networks of interaction. It's common knowledge among them that they are rational, self-directing agents. So guidance works when their understanding of the norms and the authority of those norms is in some substantial degree common. So law's directives must be publicly accessible. Publicly accessible. The reasons they give must be reasons that law's subjects can generally appreciate and readily understand that others appreciate. This need for public understanding and appreciation puts law's subjects and law maintaining officials into a complex network of interdependence and imposes on them, as Lon Fuller argued years ago, imposes on them a discipline of reciprocity, or perhaps more broadly, of mutuality. Each of law's subjects and each official must engage in a kind of triangulation then to arrive at their understanding of the meaning of those legal norms for themselves. On the one hand, law's subjects test their understandings against what they expect from officials and other law subjects with whom they are likely to interact. And officials likewise must approach their understanding of legal norms guided by the understanding held by other officials and by the public generally. That's point one. Point two, law guides not only through directives, but also through constituting networks of responsibility, of relationship, responsibilities, and statuses, which reinforce and underwrite the normative significance and infrastructure of the community. I call this the constitutive dimension of law's normative guidance, and I believe it's of really signal importance. In this way, law gives meaning to a wide range of actions and activities in the public domain and to social relationships. We talk of law's practice as a discipline of practical reasoning, but this involves more than merely uttering reasons that can be seen as premises in a practical syllogism. Because law also provides what we might call scripts that give public meaning to behavior and modes of social interaction. So actions are seen as fulfilling duties, or violating rights, or causing injuries, or fulfilling or failing responsibilities, maybe of parents or fiduciaries or public officials. Law does more than prescribe a repertoire of behavior, then. It defines a horizon of consideration for practical deliberation and supplies the infrastructure for meaningful and secure interactions and relationships in the political community. So we can see law's constitutive efforts, for example, in definitions of marriage and so family relationships, or laws define conditions for incorporation of business enterprises and for the transfer or inheritance of property. They enable the creation and maintenance of organizations and associations of all kinds. That's the crucial constitutive dimension of law, of law's guidance. Third, law guides by providing frameworks for mutual accountability, modes of interaction in which law's subjects and law's officials and agents are answerable to others who are also subject to that power, to that law. To be subject to law, after all, involves more than privately recognizing law's claims on one. It essentially involves being subject to others who are in a position to hold one accountable to that law. After all, to be accountable to oneself alone is to be accountable to no one. Law's guidance is effective when its norms are underwritten by forms and forums of mutual accountability. It turns out that that point plays a very big role in my understanding of the rule of law. You perhaps might have seen that. Now, let's talk about laws. I talked about law as a social practice and law as a normative social practice. Let's now talk about the nature of the discipline that it defines, all right? Law's discipline. In its primary habitat, the political community, the law's project of normative guidance calls for a discipline of quite distinctive character. Law is historically situated, institutionalized form of deliberative discourse regarding public matters, purporting to bind everyone within its jurisdiction, at least in part, by virtue of its being able to speak for all of them. So, in sum, law's discipline is, here's my long slogan, law's discipline is an institutionalized, discursive, collaborative, pragmatic discipline of practical reasoning that's mindful of time and of systemic coherence. Let me read that again. Law's discipline is an institutionalized, descriptive, collaborative, pragmatic discipline of practical reasoning, mindful of time and of systemic coherence. So I want to talk about each of these dimensions. First of all, discursive. Law's discipline is essentially discursive, and by that I mean it is articulate and argumentative. This is where I'm coming back to my point earlier that although law's practice is analogous to the activity of a jazz ensemble, herein lies its crucial difference, one of them. It's discursive. Now, by that I mean it's articulate and argumentative. By articulate, here's what I mean. The basic constituents of most social practices, are deeds, meaningful conduct. In law's practice, the deeds, conduct, necessarily include words. It involves efforts at making explicit and available for the public the meaning of those deeds that are prescribed or performed. Law necessarily involves judgments. In its language, claims are made, challenged, and defended. Law is the language of public accountability. Moreover, the patterns evident in this practice are patterns of reasons that are deployed in argument. So we often think about social practices as regularities of behavior. But what I'm arguing here, or pointing out, is that kind of behavior that's going on in law is typically structured in terms of patterns of reasons and argument. And so it is also argumentative. Law's discipline is a discipline of making publicly articulated arguments, uttering, offering, assessing, challenging reasons. Its moves and counter moves are moves in argument, not in a chessboard. Offering claims, counterclaims, challenges, responses, and offers of warrants for action and rejection or revisions of them. Now, the norms that emerge from this process get their content and force from the roles they play in law's networks of reasoning and argument. So, identifying and articulating the content of norms, legal norms, involves employer exploring the reasons and arguments for and against them, and conclusions that they support or fail to support. So in this case, as I said, to learn a discipline, to master, to participate in a practice is to master a discipline. To learn this discipline is to learn how to make one's way in this discursive, argumentative network, together with others. The moves of argument in this public practice involved offering reasons in public to other members of that public. So we might want to say reasoning is not ad hominem, it is, if you appreciate the Latin here, inter homines, among homines, right? Offering reasons that participants can have some hope of regarding as reasons for us. Now, this discipline, I believe, makes possible a kind of objectivity, what I once called objectivity fit for law. Think about objectivity for a moment. We don't demand objectivity in all domains of life, even in our interactions with others. In some domains, after all, de gustibus non disputandum is perfectly acceptable. It's welcome. But law is not one of them. Law's deliberative domain is the domain of public judgments. And so arbitrary or strictly personal matters that need no further vindication than one's passing whim are simply out of place in law's domain. We demand of law a mode of discourse of reasoned argument, one in which our differences and conflicts respond to argument. This incorporates into the discursive discipline certain key standards of performance. Our judgments, for example, must transcend the merely subjective. When the strictly subjective is left behind and the possibility of error uncovered by others, is acknowledged, then space is open for disagreement and the possibility of agreement, of contestation, and the potential for consilience of judgment. In this context, disagreement is not a sign of dysfunction of the practice, but of healthy engagement. We might want to say, in law's domain, de legibus disputandum est, not the other way around. Okay. Institutionalized. Unlike many other important social practices, law's discipline is learned and practiced prominently in formal institutions. The legal order is a structured complex of institutions consisting of a range of roles and offices assigned to discrete, often intricately related domains of operation and distinct functions. And they're typically arranged in hierarchies of authority. Of course, law's discipline cannot provide effective normative guidance to the political community if it is limited to the activities of incumbents in those offices. Nevertheless, their activities lead, model, and mediate the public's participation. This will become very important later. Law's institutions define structures and networks of mutual accountability, as I've argued, where those who are subject to the exercise of power by others have recourse to hold them accountable to the law for that exercise. The law enables, empowers, and disciplines this essential and essentially public activity of accountability holding through construction of these institutions. The institutionalization of law's discipline, then, isn't just incidental, it's fundamental to its work of providing effective normative guidance. There are two dimensions of this necessary institutionalization that I want to highlight just very briefly. One, forensic. Law is found and forged in courts. Within the web of interdependent governing institutions, courts take a leadership role due to their public prominence and the legally constituted authority that's given to them. Courts, in their formal structure and procedures and their daily activities, model the structure, process, and practice of the discipline. Their internal standards of performance model what we might call best practices for the exercise of law's discipline and other domains of life in the political community. Secondly, offices and authorities. Institutions are formal structures of roles that define powers and responsibilities and then assign them to officials. Officials are fitted with authority in different degrees over domains of various sizes. And these authorities typically are arranged in hierarchies. These hierarchical relations are, I want to stress, internal to the law. They are ordained, constituted, and delimited by the law's own governing principles. Thus, any account of the interpretation of law of a given domain must include amongst its components the principles by which these roles and responsibilities and relative authority of the offices and officials are legally defined. These principles are constituents of the network of norms of a given legal order. The orientation of law's discipline. Law's discipline is characterized by its distinctive orientation. Four dimensions of this orientation call for attention. The discipline is collaborative, it's pragmatic, it's mindful of time, and mindful of systemic coherence. I'm going to look at each of those four. Collaborative. Law is a social practice. Its structure is a form of common reasoning. Its discipline is a learned shared capacity. The process of deliberative reasoning is a collective project, a collaborative effort. Participants who master the discipline move around in a common world of that argumentative practice. When they make claims about what the law prescribes, they offer formulations of collectively meaningful actions and norms that govern them. Doing so, they contribute to an ongoing discourse with other participants across time. Training in law's discipline, then, involves more than training in logic. It includes anticipating what others engaged in the practice can recognize as sound reasoning, pointing to the best understanding of the matter in question. Of course, conversations may begin with proposals that don't square precisely with proposals uttered or entertained by other participants. They may not only be different, but they're discrepant, that is, in conflict with each other. However, this reasoning effort doesn't end there. Law's discipline calls for an effort at consilience of mutual adjustment of claims aimed at resolving the conflict. Because this discipline is fundamentally argumentative, participants must pursue this consilience by means of further argument, searching for further, deeper reasons that hold some hope for resolving the conflict. Now, mind you, consensus is not a precondition of engaging in the discipline, neither is an expected outcome. But seeking consilience is a regulative idea of the collaborative process. Since challenge is an essential part of the argumentative discipline, conflict at the outside and even at any stopping point in the process is not unexpected. Nevertheless, the discipline depends on a drive to consilience. When participants disagree responsibly and with integrity, they disagree about how best to formulate and express what they take to be the meaning or implications of their common activity. Participants recognize that they participate in a common activity, the product of common work. When they disagree about how best to articulate this common meaning. Time mindful. Mindfulness of time lies at the heart of law's discipline. Law orders time in and of the community, orienting practical deliberation in its cross-temporal life. Law's discipline anchors deliberation to the past, the recorded actions, decisions, and articulated rules regarded as the acts of the community. We might call this collection of the past decisions, actions, and articulated rules as the epidermal layer of law. Law-disciplined public deliberation, then, looks to the community's recorded past for an understanding of that community's commitments, and it projects this understanding into the future. Law's discipline requires deliberators and decision makers to locate the instant case, the case they're facing, in a trajectory from past commitments into a collectively meaningful future. When this trajectory is plotted successfully, it tracks understandings of the practice community and anticipates future uptake by other decision makers and those meant to be guided by the law. Thus, the status, content, scope, and normative force of legal propositions are determined by the way the courts, officials, and eventually the public have read the recorded past and are likely to take up the proposed understandings. Thus, understanding past applications and anticipating future ones are essential to grasping the import of law for the case in front of one. Note here, law's normative vitality depends on the integration of these elements into the daily practice of deliberation. Now, systemic coherence. I want to treat here together pragmatic and systemic. Pragmatic and mindful of systemic coherence are two key elements of this orientation, the last I'm going to talk about. Law's discipline calls for a degree of systemic coherence of the corpus juris, the body of law, but with a decidedly pragmatic orientation. Let me say something about pragmatic first. Law's discipline deals with eminently practical matters of concern to the political community, matters of ordering social life, and coordinating complex modes of interaction within it. So, although it may address high stakes issues of political morality, its focus and orientation is on the relatively concrete situations and problems that arise in particular cases. Its attention to systemic coherence stems from two complementary sources. One, the need to sustain law's normative integrity and legitimacy, and the other, the aim to provide normative guidance. To achieve these goals, it must view the law at any particular point in time as how Waldron once put it, a unified realm of legal meaning and purpose that enables subjects of the law to identify the path that the law marks out as pragmatically intelligible. So the pressure towards systemic coherence is not a matter of practical intelligibility, is a matter of practical intelligibility, not intellectual tidiness. So the law at its best offers those it seeks to guide a system of interconnected norms related by content, not simply an aggregate of discrete rules or directives. The content, scope, and status of legal norms are determined relative to other norms of the system. The meaning of particular legal rules is typically conditioned by their interaction with other rules and norms. Law disciplined practical deliberation then locates particular rules or reasons in a network of mutually conditioned norms. The corpus juris, the body of law, can be thought of as a kind of dynamic system that seeks equilibrium. To achieve their purposes, new rules need the cooperation of other elements already a part of the corpus. Adding new rules to the system may prompt adjustment of the rule, getting it to fit in, or it may disturb the equilibrium, forcing an internal adjustment that reestablishes the upended equilibrium. Now, this systemic integration, I think, should not be thought of as hierarchical, but as inferential. It aims to link elements by locating their place in an inferential network of reasons, rather than deriving them from more general principles. So, given the pragmatic, non-hierarchical bent of this equilibrating activity, integrating the new into the existing corpus isn't an abstract or theoretical matter. It's a matter of adjustment and accommodation with the aim of providing practical, intelligible, normative guidance. The demand for coherence of the system and practical intelligibility, it's working on the ground, if you will. These two things, coherence and practical intelligibility, are mutually corrective. Heraclitus once wrote, "The cosmos works by a harmony of tensions like the lyre and the bow." Law's discipline also works by a harmony of tensions, by the mutually tempering action of these two complementary demands. And this has two immediately apparent consequences. First of all, doctrinal coherence will tend to be local rather than corpus-wide, aimed at making a department or a segment of law practically intelligible, rather than securing broad theoretical coherence of the entire body of law. It does not demand general theoretical coherence, when possibly ill-fitting parts are not likely to overlap in actual practice. However, when the pressure does increase, when law's subjects are likely to find themselves pulled in inconsistent directions. So law's discipline, we might say, tolerates incompleteness of vision, but not incompatibility of directives. The discipline's pragmatic bent eases the pressure on collaboration to seek consilience of all divergent positions. In view of its pragmatic orientation, the consilience may be easier to achieve than deep resolution of theoretical conflicts. Conciliation may seek a working solution, leaving resolution of deeper issues for another day or time. The aim is achieving an understanding of law's requirements or entitlements that are practically intelligible to those who are implicated and are most likely to interact. Secondly, consistency or coherence of law is likely to be approximated rather than securely achieved, to be approached rather than reached with finality. The legal order is dynamic. It's always needing to adjust to changing circumstances and demands of life in the political community. Legal reasoning is willing to sacrifice a degree of theoretical coherence for practical resonance of the law in the community that it serves. So with that, I've not only talked about law as a normative practice and explained what that is, I've tried to explain this special discipline, the artificial reason. But this characterization of law is open to challenges from a number of directions. I want to consider just 3 such challenges. No doubt you could think of 33 more. All right. 3. First of all, I'll call these the problem of shortfall, the problem of conflict, and the problem of congruence. Okay. Problem of shortfall. Consider the alleged systemic or collaborative character of law's discipline, or alleged character. Any clear-eyed observer of familiar legal orders would report that there are varying degrees of incoherence evident in them. And officials and judges and others who evidently pursue their own political or personal agendas, disregarding the requirement of an effort towards conciliant of discrepant views. As descriptions of actual practice, the systemic and collaborative dimensions alleged seem fictional. I think an adequate answer to this objection is available. We have to keep in mind that the thesis that I want to argue here, law as artificial reason, calls attention to a discipline, an activity governed by performance standards, not a description of regular behavior. Compare here rules of logic or grammar, which reflect disciplines of thought and language. They don't describe actual reasoning or language use. Likewise, participants in legal practice may display varying levels of proficiency in this discipline. Just like the plumbers that come to my house have shown relatively different degrees of proficiency with respect to getting my plumbing to work. But built into the discipline are standards of performance dictated by the nature of that discipline. So, for example, judges are expected, they're required as a matter of good performance, not only to hear facts and arguments of law, but to give them the focus of their deliberative attention, usually to exclusion of other considerations that an observer who is not trained in the law might find attractive. Similarly, they must construct rationales for their decisions, their publicly articulated opinions, according to recognized standards of logical and rationally cogent argument. These are not merely ways of doing good and admirable things in the courtroom. They're standards of proper performance. Standards derived from the nature of the practice They are, amongst others, regulative ideas of the practice. Neil McCormick, for example, wrote, "The idea of system functions as itself a regulative idea within legal discourse, a concept contained within or encapsulated within our thought about law, and partly regulating or structuring it. Thus, systemic coherence and serious efforts at collaboration are performance standards of this discipline, I argue. They're not facts about the practice, regularities of practice behavior. They're regulative ideas implicit in the practice. Participants in the discipline may not meet its demand, but this would be a failure of the participants. They fall short of its regulative idea. This is not a failure of this account of the discipline. Moreover, entire legal orders may fall short of this regulative idea of the law's discipline. They don't thereby fail to be legal orders. Is not a conceptual claim, but rather they fall short of what we expect of law. I'm going to come back to that at the very end of this conversation. So secondly, the problem of conflict. Critics object the following. When legal decisions makers ignore the demand for an effort at conciliation, they don't fall short of some governing standard of performance. Rather, they actually do what is expected and required by the practice when it's properly understood. So Christopher Coote, some years ago, argued, quote, "It's a salient feature of adjudication that getting it right is more important than getting it together." Close quote. The discipline, when practiced up to standard, these critics argue, is characterized not by consensus and harmony and sweet reason, but by dispute, dissent, and dissonance. To claim that the discipline is oriented towards collaboration then fails to give adequate attention to the dissonant dimension of legal reasoning. Now, I agree that there is a tension between the collaborative and argumentative dimensions of law's discipline. Nevertheless, I believe disagreement among collaborators is welcomed and called for as a part of law's discipline. To begin, note that the nature of collaboration may vary from one practice to another. We can expect the nature and role of collaboration in law's discipline to bear the stamp of the nature of its distinctive features and aims. What does collaboration in law's practice involve? The deliberational responsibilities of, for example, judicial collaboration include mutual responsiveness and mutual support. Let me try to explain that. First, individual participants regard their interpretations of legal materials as contributions to understanding what the team, the relevant practice community, has done, working out the common meaning of its actions. This is how I've argued earlier. They offer interpretations as their best and best supported by argument, judgments of what we, the community, have done and are doing. Secondly, each participant is, if mutually responsive, is open to and takes seriously the interpretation of arguments of others. And because of its essential time mindfulness, this requires that they view their practice synchronically and diachronically, in time and across time. Their partners in collaboration are current colleagues on the court, but also colleagues in the past, and those they project into law's community and the community's laws and the community's future. Their aim is not to appease current colleagues, but to find formulations that accord with the practice over time and that they have good reason to think will be taken up and affirmed by future colleagues. Third, their interpretations are anchored in law's informational commons, the cases and other relevant materials of the law's institutional history. This informational commons is their point of departure and their constant point of reference. They're accountable ultimately to these materials, and they make a good faith effort to stay honest to them and to protect the integrity of them. Finally, they seek consilience of discrepant interpretations, mind you, not by capitulation of them or by efforts of imposed conversion of others, but only through the force of explicit argument. Efforts at consilience involve listening to and answering the arguments of other participants, making room for interpretive proposals that are likely to reduce disagreement, or postponing matters that still divide them to a later day when opportunities for consilience may later emerge. So why is collaboration important? At least two reasons, I think, for law's discipline, focus, and collaboration. One is efforts at collaboration are necessary if the law is to offer practically intelligible normative guidance. If law is to be practically intelligible, interpretations of the law must be responsive to the understanding of the various participants in the practice. It cannot be achieved or even approximated if participants, especially officials, make decisions and take actions based solely on their individual understandings of the practice without considering how other key participants view the practice and its purported guidance. But secondly, and this is important too, I think, the decisions and actions of officials are decisions and actions not of individuals, but, if you will, of the law, and thus of the collaborative, collective effort of which these individuals are a part. What each individual does can be regarded as what the institution does only if each engages in that activity as a member of this team, deliberating, acting collaborative. When they offer interpretations of the requirements of law, they speak for and in the name of the community, not in their own name. This is especially true for those whose interpretations have special weight in the legal order according to the institutional hierarchy and the like. Judges, for example, can speak the law legitimately only when they speak for the community. And they can speak for the community only if they are responsive to and supportive of the activities of other participants as well. Now, critics are correct, I think. Disagreement, dissent, and conflict seem pervasive and widely tolerated in the practice of law. Yet the critics are mistaken because this is not, as they think, deeply at odds with the requirement of deliberation. After all, remember, de legibus disputandum est. That's not simply a fact about what happens to go on or go wrong in a legal practice. It's a core feature of the law's discipline for two reasons. One, the argumentative character of law is essential to law's discipline. Law is an institutionalized practice of vigorous, critical, and self-critical argument. Mutual responsiveness is a matter of engaged argumentation. Practice is a matter of offering interpretations of legal materials, interpretations of the common practice grounded in argument. This activity is kept honest through the demand for demonstration of support and liability of all the interpretations to that challenge. Consensus, of course, can be engineered by many means, by various forms of non-deliberative force and manipulation. Consensus may be too easily won, and when it is, it's a failure, a sign of dysfunction of the practice. Consilience in law's discipline must be achieved by argument. Thus, the exchange of argument, and inevitably of disagreement, is the lifeblood of consensus properly sought and achieved in law's discipline. Secondly, and this may not have been clear until now, I think it's important. Deliberative collaboration requires participants to take responsibility for their participation. This responsibility has a distinctively moral dimension. In view of the circumstances in which law operates, the interests that are at stake, and the purposes that law typically seeks to serve. Law's discipline mobilizes personal moral responsibility, and this inevitably shapes the nature and limits of collaboration that it requires. So let me just give you an example. Judges speak for the law and the community regarding matters where moral stakes are very high, often. They depend on their understandings of the law to warrant or oppose exercise of governing power. Their decisions often have great moral significance, but judges are not merely impersonal mechanisms by which the law does its work. They're responsible moral agents. They are personally, morally implicated in their activities. Thus, they must take personal responsibility for their decisions and actions and deliberations from which they proceed. That said, judicial collaboration must not compromise personal responsibility. Collaboration calls for responsiveness in the manner appropriate to and called for by law's discipline, namely participation in the common task of working on law's normative guidance by way of argument, argumentative engagement. Thus, taking personal responsibility for one's deliberations and actions based on them encourages challenging rather than meekly deferring to the views of others when they depart substantially from what one, in one's best good faith judgment, takes to be the best understanding of what we are doing and have done. Finally, the problem of congruence. Another major objection arises from a tension introduced into law's discipline by the institutionalization of law and its modus operandi, normative guidance of the public. Professionalization of the discipline opens a gap between law's trained elite and members of the public, the ordinary consumers of law, the law's intended addressees. Lon Fuller would regard this as a failure of congruence between law and quotidian understandings of ordinary people. It's tempting to think of the relationship between, mind you, here's a kind of image. It's tempting to think of the relationship between the law and law's subjects, an analogy of radio communication. I know we don't listen to radio anymore, but people used to listen to radio. Now we listen to whatever else on the computer. But think of radio communication. Successful communication on that model depends on the message, its content, form, and packaging, and capabilities of the receivers, their natural capacities, their training, their access, their interest, and the mode and medium of transmission, that is the clarity of it, the noise in it. With this model in mind, the problem for law, as I propose to understand it, seems pretty clear. Successful communication of law faces serious obstacles due to the obscurity of the messages, the defects in the medium of transmission, and the insufficient capacities of receivers, those who are addressed, those who are meant to receive and act on it. Critics plausibly argue that as we know it, law as we know it is a vast complex of obscure rules that only the most dedicated student can master, and even they are likely to master only portions of it. Moreover, the discipline is dominated by a professional class. This, critics argue, guarantees failure of congruence. The discipline, after all, is artificial, a craft, specially learned, habituated, and dominated by a specialized jargon. It's the province of a professional elite who are protectors of a kind of Gnostic tradition. Jeremy Bentham, that tireless critic of the English common law, sneeringly called it judge and company, the legal corporation that makes the law complex, unintelligible, and detached from the practices of ordinary life in order to drive up the demand for its services. This problem of congruence looks pretty deep. Not only does law fail to be congruent with the ordinary deliberations of law subjects, that congruence, that is, that the congruence might be false. But worse, the critics argue, it's guaranteed to be false by features deep in its nature. It cannot bridge the gap between custom in court and custom in the community. I want to answer this challenge. But we need a more nuanced idea of two things to do that. One, we need a more nuanced idea of the kinds of guidance that law can provide. And secondly, the kind of congruence that's needed for genuine normative guidance. Congruence between law and ordinary lives of law's subjects is a complex matter, we must keep in mind. It comes in degrees. The regulative ideal defends a threshold of substantial congruence. Now, below that threshold, law fails to a greater or lesser extent. And there are several dimensions of that scale. We can ask how many subjects of the law, or officials, or the general population are engaged or have some grasp of the law. We can also ask how much of the body of the law must be understood by how many. Critics and defenders of law's modus operandi alike tend to assume that congruence entails that the content of legal directives, all or most of it, must be mirrored in the beliefs of law's subjects. That seems simplistic and, for our purposes, utterly unnecessary. For the artificial reason of law to provide guidance, there must be some substantial degree of continuity of the practical reasoning characteristics of law's discipline with the ordinary practical reasoning of members of the political community. It's necessary that the guidance that law gives to law's subjects is generally intelligible. It's not necessary that they pass a bar exam. The guidance offered is less than an explicitly uttered mandate or command, and more like a contribution to a publicly accessible medium, a commons of reasons, and a framework for assessing them on which law's subject can draw for their day-to-day practical deliberative needs. Also, consider the modes of governance, of normative guidance that are deployed by the law. The most familiar mode of guidance, and that which is almost always foremost in the mind of those who talk about philosophers who are thinking about law, throughout its history, the most familiar mode of guidance is the directive, modeled on commands. In this mode, law lays out a prescribed class of actions and expects, maybe incentivizes, behavior that conforms to them. However, law often guides in a very different way. It guides by giving normative significance to actions, activities, roles, and relationships. I call this, remember, the constitutive mode of normative guidance. Law defines normative statuses. It accords meaning to actions as claims against or responses to the actions of others, as actions falling within or outside the pale of a relationship, or as actions calling for or authorizing or blocking certain responses. We mentioned this before. Relations between employer, employee, marriage partners, family members, and so on. In this way, the law provides what we might call the infrastructure for meaningful interaction. To represent the constitutive guidance exclusively on the model of command distorts its role in practical reasoning. For law often guides not by supplying explicit premises of deliberation, but by providing the context of, or the horizon within which practical deliberation can take place, and within which actions and persons and groups have their practical significance. Also, law, in its constituent dimension, underwrites and reinforces, and more or less subtly shapes social norms and practices, which in turn often contribute to this deliberative medium, this commons of the mind. Law's medium of communication may at some points congeal into explicit social rules or norms or values, but often it provides the horizons of understanding, arrangements within which people interact and make sense of their social world. In political communities with mature legal systems, we're likely to find a significant amount of interdependence between formal norms of law and informal social norms, between formal law and informal social practices. Let's look at the way in which law shapes social norms very briefly. By the way, one can begin to probe this dimension of congruence or its failure only, we philosophers, only with the help of those who work in social theory and sociology. This must be a partnership between we philosophers and a number of other fields that also take as their object of study law and the communities in which law operates. So I'm drawing on some sociological literature here, not my own research, but on the research of others. First of all, some social practices, social theorists tell us, are hardly intelligible apart from the laws that shape them. Marriage is a good example, they say. Law often provides the principal categories that shape social life. Even when ordinary people are not familiar with legal doctrines or rules in all detail, their habits of mind are influenced by existing law and its thought structuring categories. Even when practices are not formally legal, and its rules are not enforceable in court, law provides concepts and terms and traditions that organize the thought and public interaction of members of the political community. At the same time, informal norms often shape formal law. Law leans heavily on social practices to give meaning to its principles and to ground its rules in the public's understanding. Social theorists tell us that ordinary people going about their daily business give meaning to what would otherwise be abstract forms. Law often operates in the shadow of indigenous social orderings. People living and interacting in law-infused situations and relationships introduce what we might call the texture of concrete social life into the text of law. Law invented at the top is often challenged or transformed or even reinvented in local practices. Finally, I want to talk about mediation. How does law, or how can formal law guide deliberations of ordinary members of society? The answer is that it may do so on the radio model of fixed rules which legislators expect law subjects to grasp and apply in their own situations. But that's not the only way, or even the main way in which it does, I think. Note that it's not necessary that law reaches all of law's subjects. And especially, it's not necessary that all of law's subjects have even a modestly secure grasp of all the laws. After all, social transactions usually take place outside of the formal domains of law and in service of objectives to which the legal rules are only ancillary. Moreover, people have other concerns than conforming their behavior to the law. They got other things to do, right? A degree of congruence necessary for law's effective normative guidance is possible even if law is accessible to law subjects only on what we might call a need-to-know basis. Moreover, guidance is achieved through a variety of mediations. I want to mention three. First, access to law for most law subjects is mediated through their participation in ordinary practices of the community and the medium of understanding in the horizons of social normative meaning, to which the law and social practices reciprocally contribute. Secondly, law subjects learn some of the law that they need to know, through personal experience. For example, applying for a driver's license, or getting a traffic ticket, or buying or selling real estate, or making a will, or filing a tax report, or the like. They'll also learn some through their interaction with officials and participation in public forums, law courts and quasi-legal institutions that model law's discipline. Sitting on juries, for example, is a common site of learning some part of the law. But third, and this is important, lawyers are key intermediaries. They provide knowledge of specific areas of law as this knowledge is needed. Law subject may not have anything approximating a comprehensive grasp of the law, but they may know enough of the basic categories and concepts to navigate successfully their daily activities and to know when they need to consult those with more expert knowledge. Professionalization of law's discipline, I think, is not necessarily a threat to law's project of providing normative guidance. In fact, it plays a crucial role in carrying it out. Thus, the possibilities for laws providing at least minimally effective normative guidance include not only directly communicating the radio model, explicit directives to each individual subject, but also contributing to the practical medium, the comments that is regularly available to members of the political community, and providing reliable and responsible intermediaries that bridge the gap between them and the formal law and law proceedings. Law, bound into the fabric of social life in this way, can give reasonably effective normative guidance. Substantial congruence, thus, is possible between law's uttered guidance and those to whom it is addressed. However, we must acknowledge that the law does not always succeed in bridging the gap between its uttered guidance and deliberative activities of law subjects. We're back to the problem of shortfall. The gap may be so great that it renders law dysfunctional, at least with respect to some substantial portion of the political community. When this is true, law fails. It falls short of the threshold of congruence demanded by its own modus operandi. Law can fall short in many ways. Let me mention two of them. The first I'll call polynomy. Polynomy. An example of this first kind can be found in colonial polities, in which large sectors, usually indigenous communities, are largely untouched by formal imported state legal system. Failing to penetrate the networks of social practices and arrangements of these sectors, formal state law can have little or no impact on the interactions of people in those sectors. From their point of view, the formal law simply doesn't count. It's irrelevant to their daily lives. But also alienation. It's a rather different form of failure. It doesn't involve competing legal orders. Euripides once said, when law is securely in place, quote, he who is weak and he who is rich have equal justice. The weaker ones may speak as ill of the fortunate as they hear of themselves, and a lesser man can overcome a great one if he has justice, that is law, on his side, close quote. However, often law does not work this way. Rather, it works for the powerful, against the powerless. Recognition of this disconnect can reasonably breed what Paul Gauder calls legal alienation. When ordinary people see that the law doesn't count when the powerful impose their will on the powerless, they may be expected to ask, well, why should it count for me? Given what they see of the way the law works, whom it benefits, whom it doesn't, who can make it work for their benefit and who can't, they may feel that they have no skin in the game. Law may fail by creating, fostering, or merely ignoring the conditions and causes of alienation of this kind. So I want to conclude. Let me conclude with just a positive word in defense of the idea of law as artificial reason. My thought is that seeing law as artificial reason helps to explain the normative claim that law makes or can make on us. Let me explain this. Law is not merely a fact of social life that we must contend with. Law presents itself as making demands, often costly ones, on us and on our interactions with each other. And it claims reasonable warrant, a kind of legitimacy, for making these demands based, at least in part, on its mode of operation, not merely on its getting justice right. Now, the habitat of modern law is a political community that is territorially bounded, in which large numbers of people who are not intimately connected interact. They seek arrangements that approximate justice, but they deeply disagree about what justice requires of them. And they look to those who exercise governing power to maintain their arrangements. In political communities with these characteristics, law's disciplined practice of public practical reasoning offers an important advantage. Some legal theorists, Joseph Raz, for example, regarded law as a surrogate for potentially conflictual practical reasoning in the public domain, displacing practical deliberation onto the artificial resources of formal legal rules, blocking appeal beyond them. I think this model fails to recognize a potentially valuable resource that the law offers pluralistic political communities. It provides materials and forums for responsibly carrying on the disputes and means of achieving temporary settlement of them that are open to reconsideration in due time and proper place. In communities characterized by pluralism, law conceived as artificial reason doesn't stop or stifle disputes over justice and other important matters of political morality. Rather, it channels, domesticates, and disciplines them. As Jeremy Waldron put it, actually channeling Dworkin, quote, "A society ruled by law is a society committed to a certain method of arguing about the exercise of political power." Close quote. Such a society is committed to justice not merely as a result, but equally importantly as a process. It recognizes the fact of pluralism and seeks a mode of debate about justice that has the potential to respect each member and respect that is modeled by argument in its public forums. Law, so conceived, provides a discipline of public reasoning, shaped by its practice in a public forum and tethered to an interconnected body of decisions, norms, and cases that are normative for the community because it represents its past and a precedent for its future. Thanks a lot.
I don't know if you can hear this, Professor, but there was actually a round of applause. Very
Lovely.
round of applause for you here, which is actually fully deserved. We thank you very much indeed. I am actually beyond words here because usually when we are in philosophical events, we are used to disagreement and objections, and I cannot find anything to disagree with in your talk, in your theorizing. And you mentioned
I've done something wrong.
and that says a lot about your talk, right? I cannot think of 33 more objections or challenges or anything. I can think of a million questions. I actually have some of them for you. I'll have mainly a few questions about your intellectual journey and how this view of law as artificial reason fits within your intellectual journey, your theorizing more generally. I'll have finally a more conceptual, sorry, or philosophical question. But first, I'll maybe pass over the microphone to Professor José Reinaldo, who might have a few comments himself as well. And I don't know, can you hear as well with this microphone? Is everything working properly for you?
For me?
Yeah.
Oh, yes.
Can
No
you hear
problem.
me now?
No problem.
Can you hear me now?
Yes. Yeah,
Sure.
yeah.
Good. Okay. Thanks a lot, Gilberto, for organizing this session. Thanks a lot, Professor Postema, for accepting our invitation. It was great to hear you, to listen to such a clear and illuminating conference, let's say, or lecture. For me, it's kind of hard to argue with you because I think we mostly agree. Also, I would say that I would say that the great point of convergence in our thoughts is the idea that law is a practice. I mean, that clarifies a lot of things with which people are dealing. I mean, if you have a clear idea of what a practice is, first of all, we could even say that talking about social practice is actually a pleonasmo, we would say in Portuguese, because every practice is social, even when you are practicing it alone by yourself. I give my students an example. You are in a laboratory doing an experiment. You're following rules which other people in different laboratories, isolated, they're also following the same rules. So first thing is this idea that law is practice. And here comes my first, let's say, question for you, or commentary, or a subject for our conversation is every practice has a sense, a reason, or a purpose. I prefer the word sense in English, and I think it in Latin would be ratio, ratio essendi, reason for existing. Ratio essendi in English would be sense. In Portuguese also would be like sentido. Every practice has a sense. And from my point of view, I would say that the sense of law is justice. Of course, it's a big subject, but you have touched it in your final, in the final part of your exposition. You were talking about justice. Maybe you could elaborate a little bit, because both in your paper and in what you have just said, you said that justice is not exactly a state of affairs or a result or a product of law, but also it's a procedure. I think that in English it makes perfect. I don't know. I'm not a native speaker of English, but I would say that in English you have a word for this procedure, which is fair. And when we translate things from English, it's very difficult for us to separate justice from fairness. Anyway, but my comment would be like this. Do you agree with the idea that the sense of law is justice? And how would you elaborate that? That would be one first question, let's say. The other thing is, I think there is a difference in what you say from my perspective, because I think that when you were talking about law as a discipline, as an academic discipline, actually, basically, that was your subject, if I understood you right. But then my idea, which you also mentioned in part of your lecture, is that law is a general way of living. It's a form of life. I think that's basic also for your last book, Law's Rule. That is, it's a way of living. And in that sense, law concerns everybody. And for instance, the man who is, or the person who is stopping at a red light is following and living according to the law, is following a rule and living according to the law. So I think it's quite interesting to think of law as an artificial reason, as you said, but I would extend, as I know you do also, that living under the law to the general public. That was actually the last part of your lecture. So maybe you could elaborate on that. And finally, the other comment I would make comes from the fact that you come from a common law country, and I come from a civil law country.
Right.
So for us, many things that you said make sense because for you, law is, let's say, produced or created in an argumentative setting, which is the court. But that's not the case for countries like Brazil, France, Colombia, the civil law tradition. Law is not made there. Law is made either in the legislative power, which I think there is an argumentation there, but it's different from what happens in courts and in the university, at the university. Doctrine. Doctrine for us means what law professors say and the concepts and systems they put up, actually. And for you, I know, doctrine is what the court says. So I think it's a point of, I wouldn't say disagreement, but I think we can talk about that because the setting for the production of law is quite different. My thought is that in the legislative process, you also argue, but you argue differently. You have to argue always aiming at the general, whereas in court, as you said, you always argue beginning from what's particular. So I think that will make a difference. But of course, we can talk about law in both settings. But I think we can elaborate a lot about that if you want to discuss legal theory in general. In Brazil nowadays, some of my colleagues, and I think they're right, they're talking about a new positivism, which is not the positivism of law, but the positivism of legal precedent. We are transforming court decisions into precedents, which can also be some sort of source of positivism in law, which actually is what happened in a way in the United States with the Christopher Langado Columbus method, which took precedence in such a way that the following or the next generations would disagree with what he was doing. But anyway, I don't want to complicate that. That's just a comment. But once again, congratulations. I appreciated your accepting the invitation. I think, I mean, you're right in your point of view and in everything you said just about. Because of course you're right because I agree with you. we both are right in that sense.
So I'm inclined to say, great, let's go off and have a beer.
Just about, yeah, thank you.
But I guess I can't do that, and I've got another half hour to talk. So let me just respond. 3 large questions, each of them worth an extended discussion. I think I want to reserve the third for a larger conversation. So let me go to the first 2. I think the third is really, really important and interesting. And we may disagree. I don't know. I might begin to say things that you disagree with about that. Nevertheless, let me just go in order. Indeed, law is a practice, and one of the and I guess it's possible an individual practice, a practice just of my own, is conceivable. It turns out that we probably are capable of even that sort of thing only because we've learned a lot about how to manage and navigate our way through social practices. We can sometimes carve out little bits of our lives that don't depend directly on them, but we kind of know how to do that because we've already developed certain kinds of skills. We often call them personal habits but that suggests that they are mechanical and intellectual, or without any kind of intellectual component. But these habits can be richly informed in various ways. Typically, we learn habits. This is Aristotle. It's probably Wittgenstein. We learn habits through our engagement with others. We can't begin to make sense of our lives until we've actually been deeply infused with the habits of those around us. Hence, differences of culture can make a very big difference in how we organize our private lives. Okay, so that's absolutely right. I think that when we talk about practice, we're talking about the practices of people together, and the question is how to understand that. And of course, much of what I wrote early on was responding to a discussion of practice, which it was going back to the 60s and 70s and 80s, where practices were thought to be primarily regularities of behavior plus some kind of attitude. So an external and internal. It's so hopelessly inadequate in understanding of practices, social practices, that I cut my teeth. This is something about journey, Gilberto. I cut my teeth in trying to think about why that just seems wrong. Okay, so practices, we often can think about practice in terms of their point, their sense, their ratio. Indeed, that's how especially, say, Dworkin started thinking about it. Every practice has a point, and he thinks what we have to do is do some theoretical reconstruction of that in order to understand how the practice issues some kind of prescription for action in particular cases. I'm a little worried about that kind of direction in which point or ratio goes, as is that there has to be a single point or the like. Or another direction that's often taken is that we talk about the function of it. And I'm concerned about talk about the function of law, because it seems to me that there are lots of points of law and there are lots of functions of law. And what I tried to do, so I agree with you that it's hard to get a grip on understanding law ultimately if you can't do it in terms of some idea of justice or approximation to justice, or an attempt for people in a community to work out justice for themselves, or all that kind of thing. I agree with that. What I wanted to do and still want to do in this whole project is to say, we can debate about the ratio for a long time, but there's something else that's really interesting about law, and that is the fact that it has a distinctive modus operandi. And we can talk about what that distinctive modus operandi is for a good while, maybe not entirely, but for a good while, without taking up this larger question of the point or the sense or the ratio of the. And so that's what I tried to do. I thought you can think of even, I don't know, plumbing, about which I know very little, except that most of the plumbers who come around here don't know much about it either. But plumbing not only has a point, getting the water to run freely and cleanly and so on, but it does it in a certain way. And the way really is what you learn. I think this is pretty much a kind of Aristotelian idea. You learn what the internal proper ways of doing things. Long before you think about the larger purpose of it. And I thought that what I could do for a while is to get on with the business of looking at what I called the implicit standards of performance um, before we take up this larger question. One of the reasons is that I would like to stay away from um, getting tied up in debates between natural law and positivism um, until we've got some sense of how these things work, a better grip on that. I think our debates over the last, I must say, 40 years or so have ground to a halt because we really haven't yet paid proper attention to how this practice is actually performed when it's performed well. Not that my proposal is the right one. I can see lots of reasons for people to object to it. But I think it seems to me we've got to do that. That actually brings me to respond to your second question, because more than anything, by identifying law as a practice in and of a community, I've introduced into the very beginning of it attention, because I'm talking about this practice in and of the community that's artificial, right? And so the issue of congruence that I talked about at the end of the paper is one that's constantly run through the whole thing. But I want to keep those two things together, because if you think of law simply as the practice within a community, you can't begin to have a grip on how it is that we have lawyers around and courts and lawmakers and sources of doctrine, because all that stuff is really kind of hyper sophisticated and institutionalized. And what we have are practices, social norms. And I want to distinguish between law and social norms, although, as one of my points towards the end of the lecture tried to make, is that there's got to be a close connection between them. And in fact, there is an important interdependence between them, but they're not the same thing. So, law that is simply the domain of the professional elite, whether that be lawyers in courts or lawyers in courts and judges, or lawyers, courts, legislatures, or legislators, or those and doctrine defining professors, whether we define there's got to be a connection here, but it can't be just them, right? So how do we make sense then of law as an artificial reason? Well, if I go one direction, the direction that my civil law friends would like to go, well, that's law understood as a body of doctrine, a well circumscribed body of doctrine, which can be managed. I mean, this goes way back. I mean, I understand this goes way back to the way we understand Roman law and all the Roman law that we have learned, or the way in which Roman law then was passed down to us after the 11th century or whatever, when Bologna founded. It can't just be that, right? So if it's an artificial, that's another form of artificial reason. But that would struggle with the same kind of connection. And what I want to do is lay it on the table. This is a kind of craft. Whose craft? What's the scope of the craft participants? How do we manage that? How do we model that? Okay. And if law is unable actually to penetrate social life to the point where it actually has some impact on what you call a way of life or a form of life, then in my view, law has failed to do what it needs to do, what its internal standards of good performance, good practice call for it. That's what I call the problem of congruence. And congruence can fail. congruence can indeed fail. Nevertheless, it seems to me it doesn't have to. So what I was trying to do is to manage just those tensions that you're talking about. I guess I've become a Heraclitean. I mean, I found I'm in other parts of my work. I'm constantly thinking about this harmony of conflicting, whatever it is, lyre and bow. And I think here again, if you think it's got to be one way or the other, what you're going to do is you're going to give up on some important part of it. How those two parts, or more than two parts, fit together, that's the intellectual, philosophical challenge, it seems to me. And that's what I've been trying to work at. So I do think then, to get to your third question, I do think then that a civil law trained person, scholar, philosopher, might not take up this way of thinking about it as I did. I mean, mind you, the talk of artificial reason comes from my doing deep dive into English common law. I mean, I've done a lot of historical work on that. I've published a book on Hale, for example. So it comes from that deep dive. I don't want to deny that. I do think, however, that the resources are there to bring my civil law friends along with me. Mind you, this is again perhaps an answer to Gilberto's question about journey. I spent about 12 years trying to put together that treatise on philosophy of law that Rinco Patro in Bologna and I edited. Why did I do it? Because I wanted to have close conversation with someone people deeply involved in that tradition. I think I have a reasonably good, though not great, understanding of that. And I think what we might be able to do, I and my civil law friends, take this image that I've tried to spell out and then see where it just doesn't fit and where it does fit and how we adjust it. That's what I like about the idea, as I said at the very opening of it. Legal philosophy can't do without images, but we have to recognize that when we adopt images, whether it be command of the sovereign or a mask of power, or a brooding omnipresence in the sky, or a set of Chalcinian norms, or primary and secondary rules, those images all leave something out. I'm very mindful that the idea of law as an artificial reason leaves stuff out. Can we attach them yet? Can we expand this image to a certain extent that it sounds more nearly right to my civil law friends? I think so, but that's a conversation, not an opinion. Thanks.
I'll be mindful of time here, just as law is supposed to be. So
Yeah.
it's going to be very, very quick. My question, I'll actually reduce the many things I had to say. The one thing I would like to ask you, Professor, it's directly related to your treatise on legal philosophy, which is a treatise, not a textbook. It is a very formative book in my thinking of jurisprudence. And by the end of your treatise, you actually relocate Jeremy Waldron's theory close to an idea of artificial reason of the law. You make a very close connection to Waldron's theorizing to that of Matthew Hale. And I think it's a very interesting approach. So I would be curious to see what are your main differences in relation to Waldron's theorizing. You also have, in my view, a very interesting and, in my view, again, correct approach to Lone Fuller's theorizing. So I would like to know how close you are to Fuller's jurisprudence thought as well. But mainly, I would synthesize my question in the following way. I used to divide your intellectual career in three main stages, I would say. There is first your work on conventions, your work on Bentham as well, and also your work on the classical common law tradition. There is then your work finally on normative guidance in your writings and Fuller's as well. And again, Again, I have here in my mind a paper that you wrote called Norms, Reasons, and the Law. And
Yeah.
that to me is a very formative paper as well. And then you have a third stage in your career, in your journey, that came to Law's Rule, and also your debate with Matt Kramer, insisting on normative guidance again, and challenging this idea of law being taken up only by its officials, the horribly sheep-like society that H.L.A. Hart has described. So I would like to know whether there was any change in your intellectual career throughout the years, or if there is a unifying thread connecting all of it. Maybe this unifying thread might be indeed law as artificial reason. I don't know, but I would like to see whether there was any major change, or
Yeah.
if there is this unifying thread. And well, my other questions, as I need to be mindful of time, I will take the liberty to direct them to you via email. So
Okay. Good.
these are my main questions for now. So I can use maybe your last 10 minutes or so in that.
Well, I see actually 4 stages rather than 3 here that I might mention. Work on conventions early on, the work on Bentham and common law tradition, the work on, so more generally, normative guidance and practice, and then Law's Rule. There's no doubt that I started my career. And I can say a little bit about Fuller. Started my career very much within the Hartian tradition. But I was unhappy with what I took to be a limited understanding of social rules and of the way in which we could intellectually, philosophically separate questions about the existence of law from our assessment of it. So the concern about explaining law's normativity without abandoning a kind of positivism, right? So the first move was that in that early paper in 1980 that tried to use game theory to explain the normativity and the nature of conventions. So it was very David Lewis oriented, very game theoretic, and very much influenced by Fuller. Fuller remained through all of it. You can hear the overtones of Fuller throughout what I said today. If you hear anything about interaction or mutual responsibilities or that sort of thing, that's all Fuller, still Fuller. But I began to think that game theoretic picture was just way too limited. And so I went on as I was working through Bentham. I mean, it's a long book. And then through the work on the common law tradition later, and including those papers on the common law tradition, and then my book on Hale, I began to see a richer notion of convention, or if you will, social rules emerging. And that's when I turned to began to see, and I wrote a paper, you may not have seen it, called Salience Reasoning, in which I argued explicitly against Lewisian understanding of conventions, arguing his argument was how in the case of where we're making judgments of salience of different examples and the like, he thinks it's a brute psychological fact about us. We see it, and I say, no, it's a form of reasoning. And I use jazz as an example, as an illustration of that. Okay, but I said, that's okay, but it still leaves out one thing, and this comes out in my treatise then at the end, and that is this practice, interactive and all that kind of thing, is essentially discursive. It's about giving reasons. It's about argument. So there's a change from mere game theoretic to something that's more nearly more concerned about the way practices work more generally, and then to the discursive character. And the talk I gave today gives you a kind of, you can see that movement right through there. Law's Rule is a new chapter, because there what I'm saying is I'm not interested in debating yet further the positivism, anti-positivism, naturalism debate. I'm setting it aside. Look, here is a principle, a fundamental principle of political morality. It's on the level of, or of the kind of justice, fairness, that sort of thing. And I want to explain that. Now, it turns out that talk about the rule of law requires that we talk about law. But I try to do that in a way that doesn't depend on taking a positivist or a non-positivist or anti-positive, whatever view. I'm saying, look, there are various kinds of things. Hey, it really helps then to think about law not in terms of its ultimate ratio, but in terms of its modus operandi. So I was able to. That's why, by the way, Professor, why I've tried to steer clear of that. I want to have something. Now, it turns out here, to get back to Jeremy Waldron, he didn't like that move at all. He thinks he's got there's a paper coming out. He gave a paper at Rutgers, and there's a paper coming out, and he says, look, Postema's got this super rich moral theory of the rule of law, and we ought to go much more narrow and formal. That's another matter. But it is this normative guidance stuff and the analysis of practices in terms of their normative character and the like. That comes out in my work on customary international law. There's a piece in Duke some years ago, so in which I try to work that out. All that's been sort of condensed into this paper. In answer to your question, where does this come? Where is this going? And the answer is, yep, it's in that first or those two essays. But my work right now is to sit down and to see whether I can put together a book of 150 pages only that puts all that together. So there'll be a chapter on argument by analogy. There'll be a chapter on the systemic character of law. There'll be a chapter on this collaboration stuff that I talked about, and I hope I can put it all together so it would be sort of where I stand now, not 10 years from now, but where I stand now on the matter.
You are already invited to come to Brazil for us to discuss this book when it comes forward. So
okay, yeah, I hope I live long enough to write it.
Sure you will. I'm sure you will, Professor. I don't think you have time for any more questions, right? I mean, it's already 4 p.m.
I'm free the rest of the afternoon. So.
Oh, really? So you think you might take a couple more?
I might take, sure.
That's
as long as they're not hostile.
So no hostility from the others. Maybe. So keep it short. So let us be mindful of time, because Professor Postema actually. So 2 questions maybe, and okay, yeah, okay. So yeah, there you go.
Hello, good afternoon, Professor Postema. My name is Daniel. Hello. So, firstly, I really enjoy your lecture. It was the kind of thing, and I mean this as a compliment. I would really, really have wanted to listen to that when I was a first-year student, because I thought it would have made the whole difference in how I take law school from first year onwards. So that's really a compliment, because that's, I think, the most important year for a student is the first year. So that's really a compliment. And now, going straight for the questions. So, I would like to listen a bit more, if you could talk a bit more about what would you take you the sort of the logical space of your argument of laws of practical reasoning to be. Because if I understood it correctly, it is certainly not a metaphysical claim. You're not trying to make sort of the metaphysical reduction or anything like that. But given your answer to Professor José Reinaldo, it is not the sort of the Durkheimian-ish style of moral theory applied to law as well. So I would like to listen a bit more on the sort of the logical space you want your arguments to occupy, and then really quickly the other point I would like to listen a bit more. It's about the stuff about getting things right versus getting things together. because then again, as you pointed out many times throughout your lecture, law, the exercise of law really deals with not power in the sense of the cynical sense of power, but it is about power being used in some way or another. And
Yeah.
then if you think about the sort of the first person perspective of the practical reasoner, the sort of radically first person perspective of someone reasoning and engaging the law, the question becomes, why should I care about the law? And then I'm a bit skeptical about the importance of getting things together versus getting things right. Because if it's about should I care about the law, then, well, I should care about the law if the law is getting things right. If the law is actually using power in the right way versus the getting together way. So the sort of the Antigone versus Creon debate a little bit.
Yeah, right.
So I'd like to bit more on that tension between getting things right and getting things together. Many thanks.
Yeah. Good point about the logical space. You're indeed right. Mine is not a metaphysical claim. I'm not sure I know how to do metaphysics, but in any case, I'm not doing it. It's more interesting to ask whether it falls into a kind of moralizing of the law, right? But if you listen to the conclusion of my talk today, you might think that that's what's going on, and that would be a fair comment, even criticism, perhaps. But I do think that what I'm trying to do is give an analysis of a philosophical description, a philosophical characterization of how law, when it works best, when it's doing things in the right way, understood by its own internal standards. It becomes a kind of analysis of a practice, of particular kind of practice, where, in my view, to do that kind of work requires that one not simply describe what's going on from the outside, but takes pays very careful attention to what those who are participating in it do and how they think about it. One of the interesting features of law is that while it's a social practice, it's a practice in which you can't do very much in it without being aware of what you're doing. Self-awareness of participants is a sort of defining feature of this. So when Hart talks about the internal point of view, what I want to say is, yeah, he was right to say we got to take that into account. And what that means is get down and dirty in the practice. Try to learn you can't really begin to get a grip on what the practice is doing and what its internal principles are, performance standards, I call them, until you've actually got into it, until you're participating in it some way. It's like describing, like trying to give an account of what physicists do without understanding any physics. You need to know the physics to understand what the physicists are doing. Philosophers of science who don't understand physics at all are bad philosophers of science. I think that's true of us philosophers of law. Now, it turns out that I'm an imposter because I'm not a lawyer. I did a lot of law and that sort of thing. My wife's a lawyer, so she keeps me honest. I mean, about a lot of things, but especially about this, right? But I think that's what's going on here. So I want to know what it's like to be inside the practice. Now, of course, the only practice, this goes back to our earlier discussion about civil law, common law, the only practice I'm really familiar with is common law practice. But I get that I want to understand. So it's going to be inevitably biased towards that. So that's why I say we have to continue to have a conversation. So the perspective is not metaphysical or moral, it's internal. I guess that's the way to put it. About getting it right and getting it together, there are two ways of taking the getting it right. The one is getting our understanding of the law right, so that on that understanding it does the right thing. It does justice. Another way of thinking about it is that you're getting it right in the sense that the way in which our practice operates is open to different interpretations. And from my first person singular perspective, this is the understanding of it. It's the right way, regardless of anyone else's thought. Now, the first of those, getting it right by making it do the right, is not the task that I think is committed to us as participants in the practice. The practice is to try to make out what practice comes to. And it is a further and very important question whether, when we get that as best we can, whether it's doing the right. And it might turn out that as an official or as a citizen, my understanding of what the law, my best understanding of what the law is, and my best understanding of how we together are doing it, it might turn out that when I step back from that and ask of it, does it do the right thing? My answer might be no. So when I'm talking about the issue of getting it right or getting it together, I'm not interested in that at that point. At that particular point, I'm not interested in whether the law does the right thing. I'm interested in whether my take on it is right. And my view here has been that law is essentially collaborative. And so for me to say this is the right and only way of understanding what it is we do, and I could ignore everything you say. My view is no. There is a necessary, a prescribed drive towards consilience that one must take into account. That's part of our practice. And so when I say getting it right there, I mean getting it right as I see the right. Whereas getting it together is getting it in such a way as we can come together to see what is the practice's commitments to this or that or some other issue that we're dealing with. I hope that helped some.
So maybe one final question. We keep it short. Yeah. If
short.
you can maybe come closer so Professor Postema can see you better.
I am right in the center of the
I see you.
Okay.
Gotcha.
Can you hear me, Professor?
Oh yeah.
Good afternoon, Professor Postema. Thank you very much for a really interesting talk. My question is a little bit of a curiosity based on the paper that I read. I saw a quotation of Rousseau, which I thought was really interesting and different to see in your work, and a work of an analytic philosopher of the English-speaking world. You say with Rousseau that justice needs to be reciprocal in the sense that it needs to consider everyone. Like, the sense of considering what we have in common and others individuals. So my question will be straightforwardly, considering also that your first stage of your work, you worked with the influence of Hume, of Bentham. Is Rousseau some kind of new influence of the new Gerald Postema, the new stage per se? And if you have other philosophical influences, if Rousseau is not the center, if you have other, that's the question. Thank you.
Thanks a lot. You're right that amongst those whom I've worked on and who no doubt influenced my own work, Hume figures very large. Bentham figures not so much as an influence, but as an interlocutor. I cut my teeth on Bentham, wrote a long book in the early 80s, and throughout all of that and various work after that, always pretty much as a kind of challenge to me. I was, however, influenced by other writers, deeply so. And I guess you can see of contemporary writers, you can see, I don't know, a bit of Rawls, a good bit of Waldron, but also very importantly, you can see it again and again and again, of Robert Brandom. Robert Brandom being a kind of pragmatist, but also very much influenced by Hegel. And it turns out that it's a kind of what do we call it? An embarrassing secret of mine that I taught Hegel for many years to my graduate students. I also taught Marx, but it was Hegel that I really and the phenomenology of all things. That's my guilty secret. And there's certain elements of that, and so I guess Brandom either influenced that or Hegel influenced Brandom. So those are influences there. But I guess the other, we mentioned it before, the other influence is not a deep and profound philosopher, but very important one, Lon Fuller. All that being said, I could not stand where I am, and I couldn't begin to do the work on Law's Rule, I must say this, without the work of Martin Krieger. And to a little bit lesser extent, but nevertheless a great debt is owed to Jeremy Waldron. I go off in different directions than they would, but I can't but say I'm standing on their shoulders. I don't know if that's the kind of question you answer you wanted, but there is that's my confessional.
Talking about the, I'll say, okay. Hegel is in the background in a way in your idea of commons, of the commons and
Yeah.
the mind. So I think it's a good influence after all.
Yeah, one must handle it with due care, but that's true of every philosopher I have ever read. I just hope that it doesn't happen to me. No due care in my case, but everyone else.
Yeah, I think your work on Law's Rule makes a lot of justice to this idea of Martin Krieger of laws
Yeah.
tempering power. I think you, and also I slight disagreement of yours. I think that it seems to me to be there when I read Law's Rule. You seem to disagree with Jeremy Waldron when he says that there is a deep connection between the concept of law and the rule of law. You seem to try to steer clear of that deep connection, but in a way, sometimes there is a slight undertone in Law's Rule that seems to me to favor that approach. So
Yeah.
there is a tension there, perhaps. I don't know.
Yeah. Well, but part of the problem here is that I've grown wary of talking about the concept and of conceptual analysis. I want to bring it out of that domain and bring it down a good bit, sort of where we rub elbows, where we clash, and where we come together. As I said, my wife's a longtime lawyer and to a certain extent politician. She thinks I'm still up there, but I've come down a whole lot from those heady days in which we could, from our studies, talk about the concept of law and expect to articulate something that is wholly universal across time and space. I'm not capable of doing that. I don't want to do that. I don't think that those who attempt to do it are doing it either, but at least I'm honest about it. And that being said, Um, I'm not inclined to say there is there has to be a connection between law's rule and the concept of law. That's where I begin to back off from Jeremy's talk. I think in part he's worried about that in his recent critique of mine, that it looks like I'm spelling out a new concept, and it's a concept of law, but of the rule of law, and yet it has all this moral trapping, and it shouldn't have that. That's not so. But I'm not doing that. At least I don't think I'm doing that. Or at least I've convinced some people like you that I'm not doing it. I don't know.
You have convinced me.
Yeah, okay.
Not for anything. We have taken 15 minutes more of your time, so I apologize for that. And
No problem.
like I said, it has been indeed a great honor. I don't know if you have any final remarks or anything like that.
No, if you have further comments and you want to address them to me, I'd be grateful. As I said, this is my first attempt to pull together ideas that have been floating around in my work for 40 years, 45 years, almost 40 years at least. And I don't know what's valuable and what's not, what's to be saved and what can be put aside. So I'd be really keen to hear from people what their thoughts are.
So we'll take one more question and then I'll let you go.
Okay.
I promise you that. Just one last question.
Okay.
Agora sim.
Hello, Professor. Can you see me and hear me?
Oh, there you are. Yeah, sure.
Make
Yeah.
it
Okay. So, very short question. Thank you for the wonderful, complete lecture. And I am not a philosopher. Actually, I am a legal historian. And that's
Yeah.
I found your reference to sociology of law most interesting when you answered the congruence objection. So, as someone who studied legal history and is worried with connecting legal philosophy with social legal research, I would like just to hear more about how we can make this kind of collaboration and what legal philosophers and social legal researchers may learn from each other. Thank you.
Yeah. Well, we don't have a long time. I have a lot to say about that, but I could give you a reference to where I say it all that I have. It's called Jurisprudence as a Sociable Science, and it was published by Virginia Law Review a few years ago. My main argument is that jurisprudence, or if you will, a philosophical form of truly philosophical form of jurisprudence must be the word is sociable. This comes from Sir Edward Coke in the early 17th century of England, and he's drawing it actually from his study of Roman law, where they said, if you want to understand law, you have to understand it in the context of divinity and something else. And he was thinking about the disciplines of religion or theology and law and philosophy. And he said it has to be sociable in the sense that a philosopher needs to be open to all these things and try to bring together what they can offer in understanding, getting a grip on the law. My view is a little bit different. My view is that a truly philosophical jurisprudence is one that is open to and wants to encourage as best as I can a partnership with, mind you now, legal history of all kinds. That's very important. You look at my work, I've been writing on Bentham and English common law for a long time. Legal history that I know, that the kind of history that I know is very important for even the views I articulated today, but also sociology or social study of law or law in society. But also, if you go across the history of thought about law, general philosophical thought about law, you can't help but see that when Aquinas talks about law, when Maimonides talks about law, when the Arabs talk about law, their thoughts are infused and necessarily connected to theology. So theology is going to have a role to say here, legal history, sociology. The philosopher is not the queen of the sciences. The philosopher is an active participant partnership in this partnership. That's how I think of it. And the whole argument for this, and there is an argument for it, is in this paper called Jurisprudence as a Sociable Science. Thanks for the question.
Professor, thank you so very much indeed for what was a rich afternoon. We are all delighted to have heard you here today. We are indeed very honored, very touched. You have friends here in the civil law tradition anytime you need. So you, like I said, you are already invited to come here in person, online, whatever you prefer, to discuss your upcoming book. I'm sure you'll be alive and kicking for a very long time. So
well, good. Thank you very much. It was a pleasure being a part of this today. And I wish you all the best.
Thank you so very much, Professor. Bye-bye.
Goodbye.